All right, good morning, everyone. This is Judge Warner. This is Civil Case 2026-004777 and consolidated cases. It's a Rule 16 scheduling conference. I'm going to take roll just in the order in which you're appearing on my randomized screen. So let me do my best and we'll go from there. First of all, Sanger.
Vlad Sanger for Vitosky Plaintiffs.
Thank you. Newman.
Kristen Newman on behalf of Crompton Hollywood.
Pont. You are still muted, or I can't hear you. Actually, will y'all do me a favor and everybody mute yourself unless you're talking? I've got some background noise going on. Thank you.
Good morning, Your Honor. Ryan Pont on behalf of Southwest Jet Center.
Thank you. McBride.
Good morning, Your Honor. Jared McBride on behalf of Allianz Global as plaintiff and defendants WW Aviation, Jet Pros, and Joseph Dumont.
Thank you. Casey?
Yes, this is Tim Casey. Good morning, Your Honor. I represent plaintiff Ashley Rosill.
All right, thank you. Saba or Saba, do you tell me how to pronounce it?
Good morning, Your Honor. It's Ryan Saba, and I represent the plaintiffs WW Aviation, Joe Dumont, and Jet Pros.
Thank you, Mr. Saba. Murphy?
Good morning, Your Honor. Bob Murphy. I represent the city of Scottsdale.
Okay, Fusatola, or am I mispronouncing that?
No, you nailed it, Your Honor. Good morning. James Fusatola from the Slavacek Law Firm representing the Bridges plaintiffs.
All right, your screen says Fusatols with an S, not an A, but
oh, wow.
I do remember your name. So, Mr. Stern, please.
Good morning, Judge Warner. Jonathan Stern for the city of Scottsdale with Mr. Murphy and as well with Mr. Benson.
Okay, Mr. Benson, you want to announce too?
Yes. Yes, Your Honor. Barry Benson on behalf of the city of Scottsdale.
All right, thank you. So I wanted to get you all together. We've consolidated the cases. I made clear in my minute entry that I don't have the ability to limited consolidate. Cases are consolidated, and when it comes time for trial, we can split it up if and to what extent that's appropriate. I suspect that's going to be a difficult decision when we get there, but that's in the future, and we don't have to worry about it right now. But I did want to talk to you about case management things. This case promises to be unruly, just given the numbers of different lawyers and interests. And so I want to talk about some things conceptually with you. And I want to, at the end of this, ask you to give me a scheduling order some period of time so that we can at least get that in place. First of all, let me just tell you, I'm happy to be your trial management judge. The chances of me trying this case are very slim because I retire about 13 months from now, and I don't expect this case is going to be ready for trial in 13 months. So just so you know, we can cross that bridge when we get to it. With respect to a scheduling order, I want to talk about motion practice because I want to do some things to manage that. But let me just ask you first, are we ready for a scheduling order, or are there things that need to happen before we get a scheduling order in place? And I don't even know if answers have been filed or I should be expecting motions to dismiss. So who wants to educate me about that?
This is Ryan Pont on behalf of Southwest Jet Center, Your Honor. As we stated in the joint status report, the NTSB and FAA are still conducting their investigation and have yet to issue a final report, which hamstrings the party's ability to conduct some discovery. There's critical pieces of evidence that we don't have access to. So from the position of Southwest Jet Center, if a scheduling order is something that the court's going to require, it is likely going to not comply with the kind of preset timing that's set for tier 3 cases. I'd envision it'd probably be kicked out a little bit longer than that.
Yeah, honestly, I'd expect that to be the case with this dispute anyway, given the number of parties. I don't expect that we're going to comply with those deadlines. Are y'all asking me to simply stay things pending that? How long does that take? And since I don't do a ton of aviation cases, tell me how that's going to affect things, depending on what they find or do. That's a big question. Why don't you answer, Mr. Pont, and then other people can add in.
You're throwing me under the bus, Your Honor. I guess I haven't thought about a stay, so I don't want to necessarily put a position on the record regarding that. I'd have to discuss with my client before we decide that. But as far as what the NTSB and FAA are doing, it's been 16 months since the accident. I think all the parties were probably hoping that we'd be close to getting a final report, if not have one already. I don't know how much longer the NTSB will require before they release evidence and issue a final report. Obviously, depending on what is stated in the final report, that may or may not limit the number of claims against different parties. But I would hope we'd have something by the end of the year would be my optimism, but I just don't have any insider baseball, Your Honor.
So what I hear you saying, and people can tell me if you disagree, that we don't need a formal stay, but if we get a schedule in place, it's going to be a schedule that accounts for the fact that we don't have that report yet, and understanding that once we get the report, you'll probably want to modify the scheduling order. Is that what I'm hearing from you, Mr. Pont?
Your Honor, I think that's accurate, and I think as long as the court is flexible with the parties and potentially submitting multiple requests or stipulations to amend the scheduling order to account for potential delays on the investigation side, I don't see a problem with that.
Thank you. Mr. Casey, you want to weigh in?
Yes, Your Honor. Thank you very much for Ashley Rosille. I'm going to defer to Mr. Sanger and Mr. Fusatola, but one thing that has worked in another case in which we've got governmental entities is to create a scheduling order that's based on the starting point of when the report's available. For example, if the report from the NTSB comes in on day one, that triggers the time period that we set forth in our scheduling order. That's an alternative to a stay.
Sounds exactly like a stay. I'm not, that stay is not a dirty word, but that sounds to me like if you're not going to do anything until you get the report, and when you get the report, we're going to key the deadlines for the report. I don't know the difference between that and a stay.
Yes, Your Honor. I can see that. Again, I can only speak for my client, but I think that we could be in the position of doing initial disclosures because it's based on the current status of knowledge. I can see doing some initial written discovery. I think the parties would probably be reluctant to proceed with depositions until we have the NTSB report in hand. But I don't think it would be a complete stay. I think there are some things that we could do. I think the federal government takes a fair amount of time. I hope it's done by the end of the year, but I think that's just guesswork on everyone's part. But that's my suggestion as one approach. Thank you.
Thank you. Mr. Sanger?
Yes, Your Honor. A couple of things I think the court needs to be aware of. Number one, this case is not the only case that is arising out of this accident. There are cases filed in Oklahoma and in Texas against other entities that would not have been subject to jurisdiction in Arizona. Number two, there are two parts to the NTSB report. One part is what we call the factual report, and that is factual information that could be used by the parties in the litigation. Another part of the report is the probable cause report, and that is prohibited by federal statute for being used in litigation. So to the extent that the NTSB says this accident was caused by whatever, that is prohibited for use in litigation, motions, basically anything. And at this point, I would be opposed to a stay because I think there are things that we can be doing to move this case along. There's damages discovery, for example. There is discovery relative to some of these other defendants that are in other jurisdictions that did work on the aircraft before it made its way to Arizona. As Mr. Casey pointed out, some initial disclosures. would be appropriate. I think there's also some information from the city of Scottsdale, historical information that is going to be relevant to a lot of the claims in the case. And we could start, I've explored what I can through FOIA, but I think there's discovery that could be done there. So I don't think we can do a scheduling order, but I don't think we should do a stay because there are things that we can be doing to get ourselves better positioned when we do have access to the wreckage, for example, and the information, the factual information from the NTSB.
My inclination is not to have y'all doing discovery unless you have a scheduling order. And I'm happy with being sort of this is what we're doing for now, and we're going to change it when we get the report. But I'm not comfortable having discovery be sort of haphazard and not under a scheduling order. But I understand your point about there are things we can do, and I would certainly like to get moving on what we can. Anybody else have another perspective on this?
Your Honor, James Fusatola, I agree with everything said by Mr. Pont, Casey, and Sanger. I think what Mr. Pont said, consistent with everyone else, let's get a scheduling order in place because some discovery can be conducted with the understanding that hopefully the court will be flexible should the likely need arise to modify that scheduling order down the road.
Okay. And anybody else have a different perspective you want to add?
Yes, Your Honor. Jonathan Stern for the city. I agree with everything that's been said. I wonder whether the scheduling order that the court would enter could be a scheduling order that does not take the case all the way through discovery, through trial, because obviously things like liability experts can't begin until the NTSB opens up its docket and releases the wreckage.
I'm fine doing that. That sounds like where we're heading. That's fine. And anybody else? Okay, let me.
Again, Your Honor, I think Mr. Stern's recommendation or proposal makes most sense to Southwest Jet Center as well. We can do some limited discovery and we can play with the calendar a bit in order to give everyone some wiggle room. But as long as parties know and they're operating under something that is concrete and not kind of out in the ether, I think it makes perfect sense.
Okay, that's what we're going to do. Let me be more specific in a minute because I want to talk to you all about motions. My concern, well, let me start with motions to dismiss. Do we expect any motions to dismiss, or has everybody filed answers? Does anybody expect to file a motion to dismiss?
To my knowledge, Your Honor, everybody has answered.
Okay.
And there are not any pending motions to dismiss.
Great. So we are past that stage. I have. Oh, I'm sorry.
Ryan Pont, one more time. I know my client has filed some counterclaims or cross claims, depending on the action in which they arise. And I don't think there's been an answer to those. So I'm not sure if a motion to dismiss is being planned on those.
Okay. Right.
Judge Jared McBride, I'll speak to Mr. Pont's point. His client filed a counterclaim against WW Aviation. The response deadline is September 1st. So we are preparing that response now.
An answer, not a motion.
Correct.
Okay. Thank you all. I asked the question because I want to do some active management of dispositive motion practice. And I'll explain to you why. Under Rule 56 is sort of a Wild West rule. It lets you file as many summary judgment motions as you want, anytime you want. And what I don't want to have happen in this case is this person decides for strategic reasons they ought to file an early summary judgment motion. And then while that's being briefed, somebody else files another summary judgment motion. And maybe there's a cross motion to that. And then maybe those motions get denied and people want to reassert their motions down the road. And we've got this situation where there's sort of always summary judgment motions going on. Or constantly somebody's briefing something and everybody's trying to play games with the timing. I don't want to do that. I've done a few things in other cases. I've said you get one summary judgment motion unless you show good cause. Not sure I want to do that here, but what I'm thinking of is creating two windows for summary judgment motions in this case. One sometime in the middle of the case, a 2-week window. That is, if you want to file a motion before the dispositive motion deadline, you do it in that 2-week window or not at all. And then another 2-week window at the end of the case after discovery is complete at a dispositive motion deadline. And what that lets me do, and you, is focus on motions at a specific time and not have to focus on motions piecemeal and at different times. Now, there's a downside to doing that, and that is once I give you a summary judgment window, people sort of feel obliged to take advantage of it. I mean, maybe right now you're thinking, all right, we'll do the discovery, and 2 years down the road, we'll file our big banger at the end of the case. Great. But now you feel like, oh, well, if everybody else is going to file motions in the interim window, maybe I ought to as well. So I think that's the downside. But I also think that with this many lawyers and this many parties, I'm probably going to see some motions. So I guess I'd like to know what you think about that. And if it's a horrible idea, just tell me. And maybe I'll agree with you. So, and anybody want to weigh in? Anybody ever done anything like this in a case with multiple parties?
Well, Your Honor, from a plaintiff standpoint, I appreciate that, and we're not going to have to be battling summary judgments at a constant pace. I think that it is going to be a case where that interim summary judgment motion is really going to prompt what you're saying. Everybody's going to file them, and then we're going to see a similar thing toward the end of the case. I think there's a lot of discovery that's going to take place, and a summary judgment in the middle of the case before the discovery is complete and the expert disclosures have happened. I'm not sure that's an efficient use of anyone's time.
So what I hear you saying is you want me to set a summary judgment window just at the end of the case and tell everybody they can't file summary judgment motions until then.
That would be my preference, Your Honor.
That's what I would ask if I was the plaintiff's lawyer. How do the defense lawyers feel about that?
At a risk of going on a limb, Your Honor, I'm going to disagree with Mr. Sanger. I think if facts and evidence and discovery prove that someone should be, or they have a dispositive motion that would get their client out of the case before that window at the end, I don't think that defendant should be strung along for the next, however many months waiting for their window and opportunity to avoid, potential liability, attorney's fees, costs, et cetera, et cetera.
All right. Anybody else want to be heard? We just covered the two positions. Here's what I'm going to do. I'm going to split this a little bit. We will have a summary judgment window at the end of the case, and I don't care whether it's 2 weeks or a month, but a window where final summary judgment motions will be filed by the dispositive motion deadline. I'm going to include in that any motions to preclude expert testimony in whole or in part. Call those 702 motions, call those Dauber motions, I don't care. And then any summary judgment motion that gets filed before that window will have to be accompanied by a motion for leave to file, expressing good cause and asking for leave, expressing good cause why a summary judgment motion before the end of the case is needed. Somebody want to push back on that?
Your Honor, Ryan Pond on behalf of Southwest Jet Center. More of a point of clarification. With the motion for good cause or leave to file the MSJ, does the court anticipate that party will also provide some kind of draft MSJ to the court?
Yeah, and the response time wouldn't start to run unless I grant leave to file. I guess that's a good question. If you think I don't necessarily need a draft, right? I mean, if you think you want to describe the motion with the leave to file. I realize that eliminates the element of surprise, which is highly overrated in litigation anyway when it comes to motion practice. They're going to get 30 days to respond anyway. So I mean, what I don't want to, what I want to avoid, there are some lawyers, and I don't know if they're in this room, that whose philosophy is we're going to file a summary judgment early, and if that gets denied, we're going to refile it after more discovery at the end. And I don't really think that's a good use of resources. It's kind of unfair too, but the rules let you do it. So that's really what I'm trying to avoid. If there's something discrete that happens in the middle of the case, then that's probably an appropriate use of a multiple summary judgment motion. So I guess which would you rather, Mr. Pont, if I gave you the choice between summarizing your anticipated motion and giving me the draft, which do you rather?
I'd prefer the former rather than the latter for two reasons, Your Honor. The first is, obviously, if the court denies leave, I don't want to have provided essentially my position to the opposing side, as well as wasted the potential client resources on a motion that doesn't get submitted. So I prefer the former rather than the latter.
I'm fine with that. Anybody else want to weigh in on this? And anybody else want to tell me this is just completely unfair and contrary to the rules and I can't do it? I'm happy to hear that perspective. Okay. All right. Here's what we're going to do. I'm going to direct the parties to submit a proposed scheduling order. Let me back up. Mike, this is the part that needs to go in the minute entry. I'm ordering that the parties submit a proposed scheduling order by November 1st. The proposed scheduling order must contain deadlines for the following. Number one, initial Rule 26.1 disclosure. Number two, deadlines for written discovery and document production. The next number, I can't remember if I'm on 3 or 4, a provision, thank you, Mr. Casey. Number 3, a provision that no dispositive motion may be filed absent leave of court upon good cause shown. It is further ordered that this scheduling order need not contain a final dispositive motion deadline or a final deadline for expert-related motions or a deadline for depositions, expert disclosure, and completion of discovery. All right. So I may clean up that language a little bit since it was off the cuff in your minute entry, but what I want is a scheduling order, but it sounds like it's sort of a phase 1 scheduling order, and we can defer the rest until we know when we're going to get that report, and then we can set an endpoint. And once we set a final, the next scheduling order, the comprehensive scheduling order, whether that's 4 months from now or 6 months from now, or 9 months from now, God forbid, that will have a dispositive motion deadline in it with a window. I don't care if the window is 2 weeks or 4 weeks, that says all dispositive motions are going to be filed in this window. That lets me manage those motions and get you here for one omnibus motion hearing where we'll spend all day and go through everything. That's down the road, probably after my time here. But that's how I want to structure it. Any questions about what we need to do for now? Okay. And these are scheduling orders. They're all subject to modification and discussion and negotiation. So we'll figure it out as we go. That covers what I wanted to talk to you about in this in this conference. Is there anything else you think we need to address? Okay. Hearing nothing, I'll look forward to getting your scheduling order and we'll go from there. Thank you, folks.
Thank
Thank
you.
you.
Thank you, Judge.
Thank you, Your Honor.